Hello, everyone. Welcome to the Environmental Law Institute's webinar, The Right to a Healthy Environment, Part 3, the Subnational Consideration of the Right to a Healthy Environment in the United States. This is the third and final part of our three-part series on the right to a healthy environment. If you're an ELI member, you can find the recording of parts 1 and 2 on ELI's website. My name is Madison Calhoun, and I'm the Senior Manager of Educational Programs here at ELI. We have a great program in store for you today. I want to take a moment to thank all of our wonderful panelists who spent a lot of time preparing great content for you all. I also want to thank our co-sponsors for the program, Delaware Law's Global Environmental Rights Institute, Barry University's Center for Earth Jurisprudence, the ABA section of Environment, Energy, and Resources, the ABA section of Civil Rights and Social Justice, and the ABA Center for Human Rights. We so appreciate their help with organizing and promoting both this event and the series overall. I also want to thank the team who helped to organize this series, Christine Perry, Carl Bruck, James May, and Nadia Ahmad. We are so appreciative of all of their work to make this timely series happen. I have a couple logistical notes before we get started with today's session. If you have any technical issues during the webinar, please let us know through the questions box or email me at calhoun@eli.org. Additionally, we are saving time at the end of the program for audience questions. Please don't wait until the end to submit your questions, though. As soon as you think of something you'd like to ask, please just submit it through the questions box and go to. I will now introduce and turn things over to our fantastic moderator. Christine Perry is a staff attorney committed to advancing human rights in the environmental context, with a particular focus on gender and disability. She works primarily on international issues with a focus on Latin America. She has experience in judicial training on deforestation issues in Colombia, environmental crimes in Peru, migration with dignity, as well as enforcement issues more broadly. Christine also works with ELI's Pro Bono Clearinghouse. Prior to joining ELI, Christine worked for Amnesty International, International Secretariat's Law and Policy Program. Her work on international human rights focused on the rights of persons with disabilities, gender, policy development, and strategic litigation. She also has experience in refugee and migrants' rights. Christine hopes to further marry the two subjects with more work on the intersection of human rights and the environment. Christine holds a JD from The Ohio State University Moritz College of Law and a BA in Spanish and Creative Writing from Denison University. She's admitted to practice law in Ohio and is a member of the Global Network for Human Rights and the Environment. Christine, I will turn things over to you, and thank you so much, everybody.
Thank you, Madison, for that warm welcome. Thank you, everyone, for joining us today. As Madison said, my name is Christine Perry, and I'm thrilled to be here with all of you and with this esteemed panel. If it's your first time joining us, as Madison said, this is the third and final webinar in the series on the right to a healthy environment. And it's set against the exciting backdrop of the UN General Assembly considering recognizing this right. The vote is expected at the end of this month. The UN Human Rights Council recognized this human right for the first time last October. So this really is an exciting time for this conversation. Before I introduce our panel, I am going to turn it over to James May, and he is going to give us a little more background on what's happening right now at the UN General Assembly. Jimmy?
Thank you, Christine, and good morning, good afternoon, good evening to everybody. So mark your calendars is the bottom line here for Friday, July 29th. That's when the UN General Assembly is set to vote on whether to recognize a right to a healthy environment. As you know, if you learned from this program previously and otherwise know, this is an idea that's been long in coming. This is also in 2022, the 50th anniversary of the Stockholm Declaration, the first international agreement to recognize the right. And since then, it's been adopted in constitutions all around the globe and by countries otherwise now exceeding more than 150 countries. And as Christine mentioned, the UN Human Rights Council recognized it last fall. So now it's before the UNGA, and it remains to be seen what will happen, but there could be countries that oppose it or at least abstain, perhaps Russia, China, India, Japan, and Iran, although that remains to be seen. And the big question that the second session of this three-part series addressed is what is the United States' position, what might it do? And it really has four options. The first is to oppose the resolution. The US spoke out against the UN Human Rights Council's recognition of the right last fall. So that's one option. Option number two is to abstain, just to sort of sit on its hands and not oppose or support the resolution. The third option is to support the resolution, vote in favor of UN General Assembly recognition. And the fourth option is not only to support it, but to co-sponsor it. It still remains to be seen. There are some hopeful signals that the United States might not oppose, but we'll see with that. And the question for today is, what might that mean for subnational development of a right to a healthy environment? Christine, back to you.
Thank you for that context, Jimmy. And so without further ado, I'm going to be introducing our panelists today. Once I introduce them, they'll be giving their opening remarks. And when that's finished, we'll have an informal conversation. And as Madison said, leave time at the end for audience questions. Our first panelist is Justice Todd Edens. Justice Edens is an Associate Justice of the Hawaii Supreme Court. Justice Edens graduated from the College of William & Mary and the William S. Richardson School of Law. In law school, Justice Edens and other law student leaders initiated the nation's first public service graduation requirement. Justice Edens served as a law clerk to Justice Yoshimi Haishi of the Hawaii Supreme Court. He then worked as a public defender for over 10 years. In private practice, he concentrated on criminal and civil litigation. In 2017, Governor David Ige appointed Edens to Oahu's First Circuit Court. In 2020, Governor Ige nominated Justice Edens to the Hawaii Supreme Court. The Hawaii Senate unanimously confirmed him. In December 2020, Justice Edens joined the 5-member Hawaii Supreme Court. Justice Edens serves on several commissions, including the Hawaii Access to Justice Commission and the Hawaii Supreme Court Commission on Professionalism. Welcome, Justice Edens.
Welcome and aloha. I am absolutely delighted to be here. Thank you, ELI, for inviting me. I'm going to share some brief remarks about the substantive federal rights, Hawaii's clean and healthful environment, constitutional provision, and the importance of the UN's recent and looming actions. Courts enforce and vindicate legal rights and obligations, but you need a substantive right to really drive a cause of action. And the rights-based approach to environmental causes of action in the federal court food chain has gone from super challenging to pretty fruitless. And that's really because you have a block of lifetime appointees, most of whom got to the court by saying that certain substantive rights were settled law, but now say they were not. So there's a sound argument that many inherent rights that are really human rights that were not written with a quill pen are now foreclosed. When I was in law school, and probably when many of the viewers were in law school and the panelists, these were Justice Scalia's relatively early years, and originalism was kind of a fringy way to look at things. It was sort of an odd viewpoint. It was really different from anything we've seen historically, anything from all the predecessor justices. But things have changed. And so what do we have now? We have a Fifth Amendment Liberty Clause that's really frozen in time from 1791, a time when men, women, and children were considered property and brutalized. Women were inferior, they couldn't vote, and even white men, unless they were rich, couldn't vote. Then we have the 14th Amendment Liberty Clause, which also seems to be shrink wrapped to 1868, where while human beings were no longer enslaved, they were treated as subhuman. Women were still treated inferior, and that was the landscape that we had back then. I know many of you who've tuned in can certainly unleash really compelling arguments that the federal Constitution's Due Process Clause or the Equal Protection Clause supports substantive rights of clean and healthful environments. But I think you need to really consider the ultimate audience here and perhaps change your channel to a new audience, which would be the state courts and subnational forums. And I'm not saying don't continue the fight and the effort, because there are important issues that need to be brought, and you want some court opinions out there. So it's a grim outlook on the national level, but things are sunny in Hawaii, things are sunny in many other places, and the legal environment in Hawaii is really as breathtaking as our national beauty. we have a rights-based approach built into our law. We have substantive, inherent, fundamental rights that are protected, and that does include the right to a clean and healthful environment. But we also have the public trust doctrine embedded in our Constitution. We also have a Native Hawaiian rights provision which protects our indigenous people from, or protects their native culture, customs, and traditional rights. I'm going to foreground a little bit of discussion about our Constitution provision on the clean and healthful environment with a couple remarks. Rights are really toothless if there are procedural obstacles that are erected, and courts often, because of these procedural obstacles, don't get to the real key questions. What does the substantive law and justice require? Instead, increasingly it becomes, do courts created rules, do court created doctrines even allow the court to consider rights, to enforce or vindicate rights? So there's roadblocks to justiciability, and I'm sure that's been topics of conversation for years. But really, should substance be subordinate to procedure? A vital feature of any constitutional amendment, if you're thinking about state constitutions or subnational constitutions, is making sure the procedure is a means, not an end. You need procedures and you need complementary laws to activate and promote constitutional provisions. Our clean and healthful environment does that. We have two sort of key features. One, in our constitutional provision, there is a standing clause, and that standing clause says that any person may enforce this right against any party, public or private. That's critical. I mean, in effect, it's almost as if trees have standing with that provision. It's a private right of enforcement, and it complements the constitutional right to a clean and healthful environment in our state. Another important feature of our provision is it's self-executing. You don't need legislation necessary to implement the provisions before you have the ability to enforce or vindicate the right. The substantive right confers a benefit, so it's a protected interest right under the due process clause, and then you have all the procedural protections under your state due process clause, which means the opportunity to be heard, to participate in our jurisdictions, the right to intervene and become a party in certain actions and contested case hearings, to submit evidence, to make argument. I'll take another pot shot at the Supreme Court. They're really contemptuous of international law, the eminent jurists throughout the world that come out with just some marvelous, well-written opinions, and they just ignore it. And they ignore global norms, and they rely on interpretive tools that really time travel back to strange and cruel times, and that's really not the right approach. But there is optimism at the subnational level in the state courts. The UN resolution that I guess is going to come out on July 29th is an incredible step, an incredible feat of accomplishment by folks like yourselves. And also, I want to sort of give a shout out to some of the other reports that have come out of the UN over the years. The special reports really mean something to open-minded jurists, both internationally and at the state or subnational level. For example, the Intergovernment Panel on Climate Change's special reports were invaluable to my court. One of the reports came out on February 27th, and then we dropped it in an opinion that came out on March 2nd. I wanted that in there so that we could be the first one to quote just the wonderful findings from that climate change report. And that was used as a basis to extend the right to a clean and healthful environment, to suggest and to say clearly that the right to a clean and healthful environment subsumes the constitutional right to a life-sustaining climate system. Our court has found that there is a fundamental constitutional right to a life-sustaining climate system. Thank you for allowing me to be here today, and I appreciate the views of everyone here.
Thank you, Justice Adams, and I'm excited to get into more of that during our conversation. Up next, we have Mari Margol, and she is the Executive Director for the Center for Democratic and Environmental Rights, where she works on advancing human environmental rights for the rights of nature. She previously served as the Associate Director of the Community Environmental Legal Defense Fund. In 2008, she served as a consultant to Ecuador's National Constituent Assembly, helping to draft the world's first rights of nature constitutional provisions. In her role with the Center for Democratic and Environmental Rights, she worked with national, state, and local governments, tribal nations, and indigenous communities in Australia, Sweden, the Philippines, Nepal, and elsewhere to advance legal and policy frameworks regarding rights of nature. We're very excited to have you, Mari.
Thank you so much. It's really good to be in this conversation. And just for my opening remarks, I just wanted to focus on several things. One is just in general, a lot of the work that we do at the center is focused on advancing the rights of nature or the legal rights of the environment. And that's directly connected to the human right to a healthy environment. So we consider them environmental rights of both humans and nature. And so many of the laws done from national frameworks such as Ecuador's constitution, as well as even very local municipal laws in the United States, they marry those two concepts, the human right to a healthy environment and the right of the environment itself to be healthy. Those two things being integrally related from our perspective. So for just instance, Ecuador's constitution contains both the human right, the constitutional human right to a healthy environment, and the rights of nature. Both of those are constitutional rights. And the courts there have determined that recognizing legal rights, constitutional rights of nature or Pachamama, that is directly connected to fulfilling the human right to a healthy environment. And so much of our work has really focused on that piece. That is the question, can we fulfill a human right to a healthy environment, to clean air, clean water, a healthy, stable climate system? Can we fulfill those human rights to a healthy environment if the environment itself does not have legally recognized rights? And so those two things to us go together. And we've seen courts begin to talk about those two things fulfilling each other. And so that's what a lot of rights of nature laws are, both recognizing the rights of nature and the human right to a healthy environment. And we have a number of those laws at the local level within the United States. And there are efforts now moving those into state level frameworks. So just to focus quickly on some latest information from the folks that we've been working with in Florida for a number of years, they have advanced local rights of nature laws, and one that was passed in 2020 in Orange County, Florida, where Walt Disney World is. So that's a right of waterways to be healthy. And they've worked on citizen initiative to advance the rights of nature into the state constitutional framework. And now recently proposed and signatures being collected for a citizens initiative in that state to amend the state constitution to recognize the human right to clean and healthy waters. So that's an active effort that's ongoing right now. And I think what's really important, and what Justice Edens said in his remarks, I think speaks really clearly to some of the really important pieces that we've learned from our experience in advancing the human right and the right of nature itself to be healthy, is that it's critically important that people, individuals, have a ability to privately enforce these rights and not hope or depend upon government to do it on their behalf. So that private right of action being built into these kinds of initiatives and efforts, whether they be at the most local level, state levels, or even national levels, people being able to defend and enforce these rights, their own human right to a healthy environment and the rights of the environment itself. And that is indeed built in to this citizen initiative that's being gathered in signatures now in the state of Florida. And another piece to it too that we think is really important is rights in constitutional frameworks, state or national, tend to be more general in terms of the language, which I'm sure many of us are familiar with, such as a right to free speech. I mean, there isn't a lot around that, and courts obviously spend a lot of time interpreting what does that mean. But we can begin to put some definition around that in terms of perhaps defining what certain harms are, not to the exclusion of other harm, but to say that these harms can and do include things such as toxins that are being introduced to the waters in Florida, for instance. And so making sure that we have the ability to enforce this, but that we have something substantive to enforce. And so that the right has, that we know that certain things are absolutely infringing upon or violative of our human right to a healthy environment or our human right to clean water, as well as the rights of the environment itself. We're seeing that more clearly becoming necessary. So I think what's really interesting and important to me in terms of the UN effort that's moving forward, because that helps to advance the dialogue and the debate world over, but also what we're seeing within different nations and at state levels in the subnational realm, is that this advancement of environmental rights is becoming more substantive, it's becoming better understood. And I think as we see environmental crises advance everywhere around the globe, is becoming absolutely necessary to our ability to protect the environment, to prevent harm, and not just constantly trying to mitigate for harm that has occurred. And that's so much about what these rights are about, is stopping harm before it happens, preventing it before it happens, because we know that if it happens, it will violate environmental rights, as opposed to constantly trying to stop the bad thing from going on and trying to clean up or mitigate for it after the fact, which is not a satisfying place to be. And as we know, we're pushing the environment well beyond its healthy threshold. And so we really need a fundamental shift in our relationship with the natural environment and how we govern ourselves toward the natural environment. To us, that really means a focus on extending and advancing legal rights. Thank you.
Thank you for that. Again, there's a lot to get into during our conversation. Next, we have James R. May, who is a distinguished professor in law and founder of the Global Environmental Right Institute at Widener University, Delaware Law School, and visiting scholar at the Hub School of Law at Pace University. In 1996, he brought among the first lawsuits to enforce Pennsylvania's Green Amendment and has assisted efforts to recognize environmental rights in Maryland, Delaware, and elsewhere in the US and multiple countries globally. He has written extensively about subnational environmental rights and has also published widely about environmental human rights. He is a special representative on harmony with nature for the International Council of Environmental Law and serves as a special advisor to the American Bar Association Task Force on Environmental Justice. Welcome, Jimmy.
Thank you so much, Christine, and thank you everyone for being a part of this and listening in. You just heard it from a justice of the Hawaii Supreme Court about the untapped potential of subnational constitutionalism on the environmental side of things. It's something that can be overlooked, and part of the purpose of this program is to focus attention on it, because one of the takeaways from UNGA recognition of a right to a healthy environment is that it can make a big difference at the subnational level. As Justice Edens notes, state court justices or courts, they have their own customs and rules about whether and the extent to which they can refer to international agreements, treaties, and the jurisprudence from other countries. They're not hidebound in the way that the US Supreme Court has become or the other federal courts have become. So actions at the UN are actions that will draw the attention or get attention from state court judges. So it can make a big difference in these forums as well. You may wonder, well, what forums, right? Well, subnational environmental rights are sort of the new, if not next frontier in recognition of a right to a clean, healthy, and sustainable environment. But don't take my word for it. Brazil, 25 of the 26 states plus the federal district have extensive provisions that recognize a right to a healthy environment. These are elaborate. They also pertain to rights of nature and sustainability and duties and a whole variety of things. We see it in Länders in Germany, where most of the Länders also recognize a right to a healthy environment, led by Brandenburgs. We see it in Canadian provinces, where there's recognition in legislative bills of rights or through court decisions of the right to a health, something amounting to a right to a healthy environment. We see it in cases from Australia, from New South Wales and other places. So subnational environmental recognition of a right to a healthy environment is here to stay as well. You may wonder, well, what about the United States? And that's something that I'm going to comment on as well in the time that I have. There are, by my count, 6 states that recognize a right to a healthy environment or something akin to that in its constitution. Illinois got there first anywhere in the megaverse. In 1970, Illinois became the first constitution to recognize a right to a healthy environment, soon joined the following year by Pennsylvania and Montana, and then Massachusetts and Hawaii in 1978, and most recently New York State just last fall. So some include Rhode Island in that as well. I'm fine with that. But of those states, 3 of them incorporate the right through a Bill of Rights. And getting back to what Mari mentioned as well, you know, this idea that a right is only as good as only so good as it can be enforced. Provisions that occur in bills of rights are more likely to be enforceable and self-executing. And we see that in some of the jurisprudence. For example, there are leading cases from Montana, where a dozen years ago or so, the Montana Supreme Court looked at the right to a healthy environment provision from the Montana Constitution and said, look, this is self-executing. And it's subject to strict scrutiny under the Constitution that requires a compelling government interest satisfied by narrowly tailored means in matters that address the environment. And then in Pennsylvania, there are two provisions in the Pennsylvania Constitution that pertain to the environment. One provides for a right to clean air, clean water, and a bunch of other things. So that's sort of the independent right to a healthy environment provision. And then it also has a trustee provision that says the state holds resources in trust for present and future generations. So most of the jurisprudence, the vast majority of the jurisprudence in Pennsylvania is under the latter provision, is under the trust provision. There's still not much at all about the right to clean air and water and what that means. So there's more to be learned from that. And there are cases that have already been brought in New York that are trying to figure out how to apply that provision in context, whether it's, but all the issues are open. There's no jurisprudence as of yet, you know, about whether it's self-executing, who has standing, what the term clean means, what air means, what water means, and so on and so forth. So that all remains to be seen. But just because a provision doesn't appear in the Bill of Rights doesn't mean it's not enforceable or even potentially self-executing. Justice Edens just pointed out, Hawaii is the leading example of that, where the provisions from the Hawaii Constitution providing for a right to a healthy environment and other things have found to be self-executing and enforceable, even though that provision doesn't appear in the Bill of Rights. So again, the point here is that there are things to be learned from these state provisions. And even the provisions that have not been found to be self-executing or enforceable, like the provisions in Illinois and Massachusetts, there are things to learn. There's court decisions from both of those states that find that those constitutional provisions make standing easier in those states. So they provide benefit in that regard, even if not guaranteeing a substantive environmental right. So there are 3 takeaways from these developments. The first is that subnational environmental rights can be more sophisticated in a variety of ways in advancing environmental constitutionalism and addressing, you know, climate change and biodiversity loss and all the things that are calamitous in today's world. The second is that state provisions can help with the substantive side of things. There's very little jurisprudence across the globe or in the United States or elsewhere about what these key terms mean. You know, what does environment mean? What does clean mean? And so on. And those are, you know, points for litigators to argue and for judges to decide. And where that can happen is at the state level, maybe more efficiently and effectively than in federal courts generally. And third is that subnational constitutional rights can be more progressive. For example, in recognizing rights of nature that Mari mentioned earlier, or in advancing environmental justice that many hope will be the future of the New York provision, or in advancing constitutional law, you know, as Justice Edens mentioned, that ideas that due process, for example, have sort of run into a brick wall before the Supreme Court, but not in state courts, in state Supreme Courts. So there's opportunity for growing and developing progressive policies at that level. So those are 3 takeaways about subnational environmental rights. And the end of this is that recognition by the UN General Assembly can help to foster and nurture and nourish environmental human rights at the subnational level. So again, thank you so much for listening to these remarks and for being a part of this program. Back to you, Christine.
Thank you, Jimmy. And finally, I'd like to introduce Cliff Villa. Cliff is a professor of law at the University of New Mexico School of Law, where he teaches courses in constitutional law, and environmental justice. He is the lead author of many scholarly articles and a book, Environmental Justice, Law, Policy, and Regulation, which is used by many law schools across the country. Prior to joining the University of New Mexico faculty, he spent more than 20 years in practice with the U.S. Environmental Protection Agency, and he continues to practice today as a supervising attorney in the University of New Mexico Natural Resources and Environmental Law Clinic. Welcome, Cliff.
Thank you, Christine, and good morning from New Mexico. I'm very excited to be here today and really thrilled to be part of this discussion about subnational constitutional rights. I must admit that I'm probably latecomer to thinking about how subnational rights can advance environmental law and environmental justice. But I think now, especially after the comments before me, I am fully on board with promoting the idea. I spent most of my time as a federal attorney, and most of my time as a federal attorney, I never wanted a new federal statute, much less a constitutional amendment. I just wanted the resources to enforce the laws that we had in hand, like the Clean Water Act and the Clean Air Act. But what I've learned over time is that those federal statutes have limitations, and they don't always protect the people in neighborhoods that really need it most. For example, the Clean Air Act is premised on meeting national ambient air quality standards that are measured over large geographic areas, things like counties or the South Coast Basin in LA. And it tells you nothing really about the air quality in a neighborhood across the street from an asphalt plant or a cement plant. And a lot of those places, a lot of those frontline communities are traditionally homes of low income and communities of color. And so I started thinking more and more about what it will really take to achieve environmental justice in those communities. And environmental statutes and compliance with regulations as they exist today will not always get there. You could say, well, Congress should fix this, but Congress has not done anything legislatively substantive environmental law since 1990. You could say that states can fix this with state legislation, and in some ways that's true, although in some ways some states are going in the opposite direction. But constitutional law is something that really can be a tool for advancement. I teach constitutional rights, and when we teach constitutional rights in law school, we're usually talking about case law from the US Supreme Court, and we've seen how case law has advanced, certainly under the Warren Court, even under the Kennedy years with cases like Obergefell. But now, and especially sort of after Dobbs, I don't know that we can place a lot of trust that the current Supreme Court will enforce even existing rights, much less advance rights that we may need to address some important issues. And so I think it really is important to start thinking about rights on the subnational level, rights on a state level. And there's a real lot of exciting activity happening. You've heard already that there's at least 6 states that have some kind of right to a healthy environment embedded in their constitution. Many other states, like the state of New Mexico, have some sort of words nodding in that direction. In New Mexico, in fact, there's been a proposed amendment, a so-called Green Amendment, proposed in our state legislature for a few years, and maybe we'll get there someday. But in other ways, we might be able to use constitutional law on a state level to advance issues, even with the language that we have in our own constitutions, whatever they are and wherever they are. One example, for example, in the state of Michigan, in one response to the Flint drinking water crisis, many people will remember lead contamination in the drinking water, over 8,000 children who may have been affected by exposure to lead in their drinking water. There were cases filed in both state court and federal court challenging that action, seeking damages. And one of those decisions reached the Supreme Court of the state of Michigan. And in the decision by the Supreme Court of Michigan, they applied and embraced the idea of a right to bodily integrity. The right to bodily integrity, which comes to us from the Due Process Clause. They cite a lot of case law from the US Supreme Court on the right to bodily integrity. Of course, one of those cases is Casey, which comes to us after Roe versus Wade, and we certainly hope that right of bodily integrity and personal autonomy survive Dobbs. But now we see a state Supreme Court citing constitutional rights to protect their people. And one of the interesting things I said is that whatever the right of bodily integrity means, it does not mean poisoning your own people. And so we start to see courts that are willing to take constitutional theory, even from the US Supreme Court, and apply it on a sub-national basis. Now, it's great if a state actually does have a right to a clean and healthy environment in their state constitution, and we see that some states do. Another state that Jimmy mentioned was the state of Montana, which also has this beautiful language in their constitution. Right now, they have a case that is heading to trial probably next summer, known as Held versus Montana, and I'd urge people to keep an eye on that one as well. That is another sort of youth climate case. There have been multiple motions to dismiss, all of which have been denied. And the plaintiffs in that case are seeking some kind of remedy that will address the state's current energy policy, that will require some affirmative actions. And some of these are admittedly very technical questions. How do you fix climate change on the state level is no easy question, but there are ways to use courts to help begin to answer them. For example, courts could appoint a special master to really investigate both the science and some of the remedies. And that's one of the prayers for relief they are seeking in Held versus Montana, not thinking that the court itself can solve climate change, but that smart people, when they come together, probably can. And another thing that this litigation is doing is, I really hope, helping people come together. Most cases in the end do settle, whether it's civil or criminal litigation. And when people are encouraged to sit down and try to settle litigation, maybe they can make better decisions in the future than they have in the past. Thank you.
Thank you for that, and thank you all again for being here. So let's start with something I think all of you mentioned about constitutional rights and self-enforcing or self-executing is really the gold standard in this case. But what would you say when people might argue, well, state laws address this, state environmental laws, state human rights laws packaged together achieve the same end? How would you agree? Would you say maybe, but?
Well, I have a short answer to that. So in our Constitution of the state of New Mexico, buried at the back, Article 20, Section 23, is a right to our state's beautiful and healthful environment. But second sentence is, and the legislature shall provide for control. And if the legislature chooses not to, maybe that's a political question, and then nothing has really happened since then. So if the rights are not self-executing, if a plaintiff can't go into court to vindicate the right, if we have to wait for the legislature forever to act or not act, we may not be able to advance these rights and achieve the protection that we really need, particularly now in the era of climate change is here, but also people who are breathing air across the street from the asphalt plant today. So self-executing is very important. That's an amendment that we hope to see in the New Mexico Constitution, and we certainly admire states who've already gotten there with self-executing provisions in their constitution.
Yeah, let me add this too. For those states or those advocates who are trying to propel these constitutional provisions into your states, that's a very good point that Professor Villa just made. You cannot have that provision say something to the effect of as provided by law. That is a mechanism to simply, there'll be no action from that. I mean, because then the legislature can just sit on that and not effectuate the constitutional provision that the people have propelled into their constitution. So it's really absolutely important that these provisions be self-executed.
All right, and I think most of you did touch upon this, but I think it's really important to address how are environmental justice concerns being addressed in these types of amendments, and also the communities most impacted by climate change, environmental degradation, such as EJ communities, persons with disabilities, Indigenous peoples. How are they being brought into the fold to these conversations around these types of amendments? I know public participation is a human right, but that's not always the end goal. It's a means to an end.
I would say, I mean, that's a great question. I would say not enough, but getting there. There is not an Environmental Justice Act at the federal level, just like there's not a Climate Protection Act or anything like that. And there isn't even really a field of, I mean, arguably of environmental justice law. There's environmental justice policy, but there are a few ways to bring private causes of action, much in the ways that I won't bore certainly this panel with it, because Justice Edens mentioned earlier, but the federal courts haven't been open to due process claims on, in essence, promoting environmental justice. They haven't been open to equal protection claims, or claims under the Privileges and Immunities Clause hardly exist at all. And I could go on and on, Civil Rights Act and so on. So it's really hard to get there. So again, this underscores the value of subnational environmental constitutionalism, that there are opportunities at the constitutional level to advance environmental justice that don't exist under law at the federal level. I think New York is a great example of that. Now, the New York provision doesn't expressly mention environmental justice, but the provision that voters in New York overwhelmingly approved by more than a 2-to-1 margin last November 2nd is really an effort by many to address environmental justice, to address Asthma Alley from Queens up through the Bronx, to address the improvident despoilation of land throughout urban areas in New York, and how a lot of people are disproportionately affected. So I see promise in that law being used for that purpose in New York. And then it stands to reason that, as environmental justice law and policy grows, that it might be time to revisit, for example, the Illinois provision to see if it can be stretched into new shapes that weren't recognized when it was enacted in 1970.
I think another thought, maybe particularly important in New Mexico, is the role of tribes and tribal sovereignty on this question. Our clinic at UNM represents tribes who challenged a rule under the Trump administration that would have almost eliminated protection for waters under the Clean Water Act. The Trump rule eliminated protection essentially for ephemeral waters, which is at least 87% of waters in New Mexico, 100% of waters for some tribes. We get water in our rivers after spring runoff. We get water in the rivers after summer monsoons, and those same riverbeds may be dry for other parts of the year. If that's not protected under the Clean Water Act, it needs to be protected in some other way. That water is life for those communities. And if there's not a statutory remedy for protecting that water quality from the impacts of uranium mining, for example, then there needs to be some other authority to protect that. That other authority could be filled by state constitutional law or even tribal constitutional law. When we talk about subnational, it's not always state governments that we may be talking about. So constitutional law may have an essential role in protecting environmental rights for people, and particularly communities who depend on those natural resources.
I just want to build on what the professor just added, which is we do quite a bit of work with tribal nations to advance environmental rights within tribal statute, tribal ordinance, as well as tribal constitutional frameworks, because for much too long, Indigenous peoples within the United States have seen their rights trampled, environmental rights and other rights, and building in environmental rights protections, both the human right to a healthy environment and the rights of the environment itself, into their tribal constitutions and statutes is becoming more and more, coming more and more to the fore for tribal nations, in order to be able to have the authority to protect the environment, both on tribal land or on tribal reservation, but also off, because the traditional lands, the treaty guaranteed lands that many tribes signed treaties with the federal government, they don't currently have the legal authority to protect the environment on those non-tribal but treaty guaranteed lands that they've been guaranteed to hunt, fish, and gather. But that doesn't mean a whole lot as a right, as a treaty right, if you don't have the ability to protect the things that you're hunting, the fish that you're seeking to fish under your treaty guaranteed rights. And so some of that is now beginning to advance within these frameworks, such as the White Earth Nation in Minnesota. We assisted to draft their rights of monomen or wild rice law, which recognizes that wild rice itself possesses legal rights, but also that tribal members have the legal right to the rice. That means that the rice has to have the clean water and the freshwater habitat that it needs to be healthy and thriving and robust as a species, such that the tribal members have the ability to go and harvest that rice. You don't have one, you don't have the other. So those rights become dependent on one another, and it's another form of human right to a healthy environment that is beginning to emerge through tribal law.
Thank you. And Justin Edens, I don't know if you've seen this play out in the courts in Hawaii, if most impacted groups are bringing claims under this constitutional right.
Well, as I mentioned, standing is broad. I mean, you can get into court in Hawaii and enforce and vindicate the right to a clean and healthful environment. The way it's played out here is primarily in the regulatory context. Parties are challenging, for example, utility commissions, power purchase arrangements, and other types of utility actions. That's one area we've seen the constitutional provision in play. Additionally, infrastructure development projects, the constitutional provision of a clean and healthful environment is in play. Now, it's often in tandem with our public trust doctrine as well. So it's sometimes the decisions or the opinions that come out are grounded in the public trust doctrine. But the clean and healthful environment provisions have certainly been exclusively used in the utility context. We have not seen the grand type of tort cases such as Juliana or the one that's progressing in Montana yet. We haven't really seen declaratory relief cases yet as well. One important aspect, though, as I mentioned, is our provision, again, provides for due process protections and all the things that go hand in hand with that, which is meaningful participation. Is we have environmental organizations that actually are parties in some of these utility commission hearings. There's contested case hearings where they can submit evidence, they can cross-examine witnesses, they can argue, they can hold the government responsible for their affirmative public trust obligations. So that's how it's played out. There is a case that's just at its infant stage that is more in the lines of a future generation type of challenge.
Thank you. And you did mention the case that Cliff brought up in Montana. Cliff, could you give us that name again? Someone in the audience is inquiring.
Held, H-E-L-D, Held versus Montana.
Thank you for that. And you talked about briefly in your opening remarks, Justice Edens, that state courts are more open to international interpretations, to what's happening in the international sphere. And I'd like to ask all of you, do you think a recognition of this right by the UN General Assembly will spur effort at the subnational level? And in turn, do you think that might help momentum at the national level in the US?
Well, I'll jump in. I thought I'd just talk, so I didn't want to hog the time. But you know, state courts, as I mentioned, they're way less dismissive of international actions than Fed courts. I mean, I like to consider our court, at least, as quite open-minded. We will take a look at anything. So the measures that the UN has taken are invaluable. Now, and I do believe other courts are like-minded. So when you have these types of really incredible declarations and resolutions and work products such as those special reports, how can you close your eyes to them? And I think that they do provide meaningful interpretations and science that courts can use. So I think it's incredibly valuable. Now, whether there's momentum to use those yardsticks and those just wonderful products that come out of the UN and elsewhere from scholars like you folks, from scholars, around the world, on the federal level, again, I have it's a very grim outlook in my view. But again, it's not hopeless. Let's look to the subnational level, and that's why we're really here today.
It also might, I think that's hopeful, Justice Edens, as well. I mean, that courts in the United States in particular will, at the state level, will look at the UNGA resolution as incentive for doing more with the law. And we see that in cases in the US under other socioeconomic rights, like a right to life that most state constitutions, I think all state constitutions, guarantee. And what we see is jurisprudence from all around the globe aligning a right to life, for example, with a right to a healthy environment, cases in India and Pakistan, Bangladesh, Nepal, and elsewhere. So maybe, again, just maybe, taking note of what's happening in New York City on July 29th will spur on judges to look again at some existing provisions to see if there are new ways that they can apply to new problems.
I would also add that I think we need to look at what courts might do, but also what people might do. Because in our experience, so much of the kind of change we're talking about, whether it be at the most local, municipal level, at state level, and even at national levels, I mean, it's people who are gathering together to demand these kinds of changes and driving it into law or even constitutional frameworks. And in our experience, not with the UN, but when Ecuador promulgated its constitution in 2008, so the first national constitution to recognize the constitutional rights of nature, people really all over the world, but including within the United States, were energized by that. Were able to see something that they hadn't seen before about what is possible, about how we protect the environment, how do we raise environmental standards. And so I think the UN's action could spur that kind of energy within the United States so that people are motivated and mobilized to drive these kinds of rights from the local to the state and even to national levels.
Thank you. And talking about sharing, taking inspiration from one and another, have you seen that in states within the United States looking, well, Pennsylvania did this, so do you see that type of sharing, or how do you see the interaction between the states in this sphere?
I would say that in our own legislation in New Mexico to create a green amendment, we spent a lot of time looking at what they've done in Pennsylvania and Montana and most recently in New York. I think every state may approach things a little differently, and that's what you want, states as laboratories, but it's exciting to see what has already been done. And we've also learned some important lessons from that experience. Professor John Dernbach has a beautiful article about the Pennsylvania constitutional language and how it was effectively mooted for decades until it was recently brought back by cases, including Robinson Township. And so it tells us that it's not enough just to have beautiful words on paper, but we need to take care about how it is implemented to make sure that courts interpret it consistent with its intent, because we don't want to end up with the most beautiful language we can imagine and then not have courts enforcing it as was written. So we've learned a lot from those experiences, and I'm sure that we'll continue to learn from each other as we go forward.
Thank you. And I want to turn to some of our audience questions now, since we're getting quite a few. One is about a ruling from Florida that state law preempted establishing rights of nature that had been approved by the Florida voters. And does this mean a change to state law has to happen before these rights of nature can be secure?
So I'll respond to that. There has been, as I mentioned, the Orlando County law that was passed by voters in 2020, and a case was brought to enforce those rights by waters within the county because their own right to exist is being threatened by commercial development. And under Governor DeSantis, the state legislature, upon seeing that people were seeking to legalize the rights of nature, promptly put in legislation to preempt communities, so withdraw or restrict the ability of communities to actually even recognize that nature, has even the right to exist. And the Florida court just said that the Orange County law is preempted by that state legislation, and I expect that ruling to be appealed. But meanwhile, there has been legislation introduced in the Florida legislature to reverse what they did in terms of preempting. This, of course, isn't the first time that we've seen state legislators take this kind of action. There's been a preemption law in Ohio on rights of nature. And of course, there's preemption laws all across the United States at the state level, preventing localities, municipalities from doing certain things to protect the environment. And those laws are largely written by and for industrial actors who don't want to see local communities interfering with their ability to pollute, their ability to emit, their ability to build and develop, and even in things like in Orange County to destroy wetlands to build a new strip mall. So this is happening across the board. It's not specific to the rights of nature, but it's certainly happened in that case, and people are mobilizing, of course, to change that.
Thank you. The next question, I think, will be directed to you, Justice Edens, and essentially it's asking, what remedies do judges have in these types of cases that are enforcing these rights?
Well, there's a broad scope of remedies on the menu. Professor Villa highlighted the notion of special masters, and I think that is a really good approach because the courts don't want to micromanage, and the courts don't have the expertise. Presuming a party prevails, what's the remedy? How are you going to cut your greenhouse gas emissions? What's going to happen? I mean, it just opens up so many complex issues, and the court really can't stand there and micromanage these types of things. So I think it's really important as one possible remedy to have an expert to oversee whatever the court enforces or vindicates. And that I see as the approach moving forward.
Thank you. And one question that came in is, do these provisions apply to indoor environments as well as outdoors? Do they need to be specific?
These are indoor. No, I'm kidding. No, so these are, right to the healthy environment. It's ambient environment. It is an indoor environment. At least I'm not aware of any judicial interpretations of any of these provisions applying them in the workplace or otherwise indoors. But again, I'm happy to be corrected about that.
Yeah, I would just say that states can certainly regulate indoor air in indoor environments. The state of Mexico does that. Many other states do in their version of the Clean Air Act. So states are, designed to do more than the floor established by the federal government. If they had constitutional authority to promulgate those regulations, they might be safer, but there really hasn't been a substantial point of question here. If the federal government's going to do it, we need that, interstate commerce, and the Supreme Court, U.S. Supreme Court, has been more and more sticky about, what interstate commerce looks like, but most states are not held to that same level of standard.
Thank you. And this next question is rather topical, and it's wondering, can these rights apply to stop the rise in cryptocurrency that increases greenhouse gas emissions? It's a very specific question.
Could you repeat the question, Christine?
Yes, I'll repeat it. So, does the panel think that these environmental rights can be applied to stop the rise of cryptocurrency mining, which increases greenhouse gas emissions?
I would just quickly say in response to that is these rights can become more defined or more specific, and in particular include prohibitions. And that could include prohibitions on fossil fuel development, fossil fuel extraction or burning, or certain industries or activities that raise global greenhouse gas emissions, something like that. So those rights could be defined. And just one quick example of that is in Ecuador, in a case that was decided last year, the Constitutional Court there determined that by mining in a fragile ecosystem, in the habitat of an at-risk species, mining in those kinds of circumstances is a violation of the rights of nature. And so it's a very clear standard that's been set, and those sort of standards or criteria could be built in to environmental rights.
Thank you. And then this question starts with Blackstone posited the relationship of rights to remedies. In Juliana, the Ninth Circuit said there was no available remedy. Are remedies at the state level different from those available to federal courts?
You know, the remedy decision in Juliana was just a guise to avoid the substantive issue. I mean, and I want to go back to some of my remarks earlier, and I don't mean to be so grim on the national outlook and to suggest that cases should not be brought up that chain, because what happened in the Juliana case is you had a wonderful district court opinion, then you had a nice dissent as well. And those types of written documents, much like the UN's documents, can really advance and promote ideas and interests. So don't get discouraged there. But the remedies vary. It's like the other question about the cryptocurrency. Many things are fluid here. I mean, we don't know what's actually going to be, how cases are postured. As from the judicial branch, we just get cases. We don't create them. We don't frame them. And that's why it's absolutely important to have really well thought out cases that advance, and entities like Earth Justice and many of the other really solid environmental groups really strategize about how they want to approach cases, and the remedies sort of go hand in hand with that. Is courts aren't going to just invent remedies. Usually in the complaints that crop up, there's suggested remedies. Now courts can do whatever remedies they ultimately want, under their powers, but it's obviously there's got to be a nexus. The courts on the justiciability issues that sort of block things, like the remedy situation in Juliana. That's what I meant by in my opening remarks about how there has to be sort of complementary and procedural types of mechanisms to go hand in hand with your constitutional provision, because then cases don't get knocked out or short-circuited or kneecapped at its inception.
Thank you. And we have a question asking about how will these types of amendments affect the hyper-local level, such as the municipal level?
I would say one example is there is still climate litigation pending around the country, including cases brought by the County of San Mateo in California. They have survived multiple motions to remove that to federal court, where the defendants think they can get it dismissed, and the courts have returned it back to state court. State courts are good at a lot of things, including just calculating the amount of monetary damages. How much did it cost to replace your state highway or your bridge that was affected by climate events? So there's some things that don't require solving the climate problem, but if you can put a dollar price on it, you start to send signals that maybe we need to change our behavior in some way to address that and prevent damages from occurring in the future. So some things are not as really complicated as solving the global problem, but can have some sort of pressure on helping to address that problem case by case.
If I could add to that, at the local level, again, it kind of remains to be seen, and it's on a case by case and a state by state basis. Every state has a different constitution. No two are exactly alike. Judicial customs are different from state to state, and so on and so forth. But so far, we haven't seen much resistance to local action And what I mean by that is we haven't seen constitutional rights to a healthy environment as preventing local governments from acting. The cases in point thus far are primarily in Pennsylvania, where there, challenge after challenge to local government action have been cast asunder. In essence, courts upholding local government activity, even in the face of the Pennsylvania's Green Amendment. On the other hand, what these environmental rights provisions can do is embolden local governments as well to be more bold and to be more assertive about protecting everyone's right to a healthy environment because they have this constitutional backing. And just to conclude to follow up on something that Cliff said, like at the city level, just the talk of having a right to a healthy environment in Maryland helped encourage the city of Baltimore to bring a lawsuit against carbon majors that's still working its way through courts. So again, there can be these normative effects, these psychological effects, and these legal effects that UN General Assembly recognition can have reverberating throughout states, at least in the United States.
Thank you. And this will be our last question because I would like to give everyone a minute for closing remarks. And Cliff, this one is directed to you. And you had mentioned the intent of the right. Can you elaborate on that a little bit more?
Yeah, well, some of these environmental provisions date back from that heyday of environmental enlightenment in the early 1970s. And New Mexico got one of those provisions about our beautiful environment, but it turned out to be not very enforceable. But there was an intent there, and you could read a lot of what people were thinking about. A lot of people were talking in the early 70s about protecting not just present generations, but future generations. That is a really exciting concept that we're still struggling to find ways to implement. But I think that as we develop new case law and green amendments, we can honor the original intent of a lot of good thinking that has been out there for 50 years in some cases, just finally finding ways to make it stick. And so that's really what I'm talking about with original intent. There's a lot of good thinking that has happened in the past. We just need to find ways to make it enforceable and work for us in the future.
Thank you. And Justice Evans, let's start with you for closing remarks, please.
I want to talk a little bit about judicial education. ELI has been at the forefront of judicial education training, and the defense industry organizations are particularly adept at putting on high quality programs, and they do this several times a year. And so as we progress into sort of a more movement to the subnational or state level, I think it's absolutely vital to have judicial education programs for state and subnational justices, or in appellate court judges, and even trial court judges. We have environmental courts in Hawaii. Our environmental courts handle all the environmental cases. They have training every single year. Now, the favorite topics of the defense organizations are judiciability issues, standing, preemption, political questions, and other mostly court-created procedures for short-circuiting cases. And I think that there needs to be a lot of attention played in judicial education and judicial programs to advancing the environmental rule of law, and make sure that the environmental rule of law, just like other fundamental rights, should be treated with the same interpretive tools. So I really do think it's vital to lubricate the minds of jurists with judicial education programs. Thank you for letting me participate in your program.
Thank you for participating. And Mari, any closing remarks?
I would just say two things. One is I think what Justice Evans said is really quite important. We've done some CLE classes on environmental rights and rights of nature through Lawline and NACLE, which are available pretty much all over the country, and which certainly we welcome anyone to take those legal CLE trainings. And the other piece I would just add is we've talked a lot about enforcement today for obvious reasons, but another less sexy perhaps side of this environmental rights is just the implementation side. And by that I mean working with environmental agencies and regulators to create new criteria, new standards, new decision-making processes to realize the promise of these rights, so that we're not just always going to court to try to stop something bad from happening, but that we actually are shifting our government decision-making, our agency permitting decisions to actually fulfill and meet the standard that these environmental rights set. So it's not just an enforcement piece, which is critical, but also that we have this active, proactive implementation side so that we're really shifting how we govern ourselves toward the natural environment to meet that high standard that legal rights set. Thank you.
Thank you. Jimmy?
First of all, thank you again for inviting me to be a part of this program, this terrific conversation. I just have two things. The first is that the UNGA's recognition of a right to a clean, healthy, and sustainable environment doesn't need to end just there. You know, environmental constitutionalism takes all sorts of different shapes. There are constitutions all around the globe that instantiate constitutional rights to other environmental values like sustainability or rights of nature or participation and information and access to justice or environmental justice. So at the subnational level, let's not forget that there are other values to promote. Second is it's not just about what can be done in a court. There are ways to advance environmental constitutionalism and environmental rights and all sorts of other ways, as my guess is a lot of people who are watching this program are doing and have done. And just the codicil of that is, nonetheless, notwithstanding what I just said, let me speak out of both sides of my mouth. Sue, bring cases. You know, the Robinson Township case is known as the Robinson Township case, but the primary movers of that case was the Delaware Riverkeeper Network. You know, a super important organization that's been protecting the Delaware River for more than 4 decades. So that led to Robinson Township, its efforts did, which led to the Pennsylvania Supreme Court, not the US, the Pennsylvania Supreme Court, finding that environmental rights and public trust in Pennsylvania that are embodied in the Pennsylvania Constitution are on par with other rights. But it took a lawsuit to get to that. And you never know what you're going to get. And lawsuits are, you know, hard. They take work. They're expensive. They take expertise. But they take people who care. And so my ending message is for those of you who are, you know, next generationers, you know, millennials, Gen Zers, Gen Xers, what have you, is to sue, is to try to put those provisions into play to get them before forward-looking and progressive justices like Justice Edens or judges like Judge Aiken or Judge Staten to see what more the law can do to promote a right to a healthy environment, as hopefully the UNGA will recognize on July 29th.
Thank you. And Cliff?
Well, I suppose just building on Jimmy's last comment, we should not be afraid of using the courts. That's what they are here for. And they don't always need to go to a judgment, but they can help to bring people to the table in some ways and get some forms of resolution. And sometimes you do need a decision. And they can provide creative remedies as well. In New Mexico, we had a recent decision that finally found a fundamental right to education under the state constitution. Well, if you have a right to education, what does that entail? Maybe it entails the right to drinking water fountains in the school building that are safe to drink, or rights to school lunches. We have profound issues of poverty in New Mexico, and maybe there's other issues that we need to address at the same time under existing authority. So I really encourage my own students, I encourage everyone to think creatively about using whatever authority we have in hand, and then always being open to settlements and even being open to resolutions before litigation. We need to involve the private sector in so many ways, and we need to involve regulators in so many ways. The people I met at EPA are there because they care, they want to do the right thing, and they get sued again and again for everything they do. But if we could encourage them to do their job, you know, do environmental protection, don't always wait for the fish kill. I think there's going to be a lot of people who are very receptive to that idea on every side of any potential caption. So allowing people to do the good work that they want to do anyway, you know, whether it's because they're acting pursuant to constitutional authority or just because they understand that to be a part of their job, I think could go a long way with or without litigation.
Thank you, Cliff. And thank you again to all of you for joining us today. Thank you to our audience, to our co-sponsors. Madison?
Yes, thank you so much, everyone. That concludes our series on the right to a healthy environment. Thank you so much to our fantastic panelists. Thank you, Justice Edmonds and Mary, Jimmy, and Professor Villa. Also, a big thank you to Christine for moderating. And again, a huge thank you to our co-sponsors and everyone who helped to organize this event. We hope you enjoyed the series, and you can find the recordings at eli.org. Today's session was also recorded, so you should be able to view it online in a couple of business days. Thank you again, everybody.
Thank you.